we got a very good chance to get this case remitted to the High Court for a full trial to determine on the merits of the case. So because the merits is yet to be heard, merits of the case is yet to be heard, so all we want is a fair trial for the appellant who wants to know the religion of her husband.
So what about claims that she was informed about the Syariah Court proceedings and she refused to attend?
No, she was not informed. The appellant Kaliammal was not informed at all of the Syariah Court hearing. No notice was given. In any event, she has no jurisdiction to appear before the Syariah Court. She can't appear before the Syariah Court. She can't make any application before the Syariah Court. She was not informed in the first place. There was no notice given of the hearing. But order was obtained, which affects her right. Order was obtained that affects a fundamental right of the deceased husband.
So you mentioned that this represents a fear among non-Muslims that the Syariah Court may decide on cases involving them.
Yes, so it's very frightening. It is very frightening to see what has happened in Kaliammal's case, because there is no opportunity for a fair trial, no access to courts, no notification. Rights, fundamental rights of a particular individual has been affected. So that is the reason I fear, everybody, non-Muslims fear, that if this thing if this thing can happen to Kaliammal, it can happen to anybody.
And even if they are to appear as witnesses in the Syariah Court, it would only be to intercede to the cooperation of the Majlis Agama Islam, which may not happen in most cases.
Yes, Syariah Court is for the Muslims, those who are professing Muslims, whereas the appellant here, Kaliammal, is not a Muslim.
They claim that she can appear as a witness.
As a witness, but that doesn't give her the right to be heard on the merits of the case. Right to produce evidence, right to call witnesses, right to say what she wants to say in the Syariah Court. So we don't want the public to see decisions which are biased. We want decisions which does not seem to be biased in the normal, ordinary citizen. That is the most important thing.
In this particular case, when it came out in 2005, it was a major case, the talk of the country. Then the Barisan Nasional said that they'll be looking into the amendments. And last year, the Minister and the Prime Minister's Department, Nazri, came out to the public and said that now we are going to do the amendment, and the amendment has been done, and it has been the draft has been done, and it has been handed over to the Rulers' Conference. And during the Rulers' Conference, we were told that it was handed over to the State Religious Department. It's 1 year, and it's there. Nothing has taken place. As far as this case is concerned, they can argue that the non-Muslims can go and testify, but that is not the solution. We want solutions. What is so difficult for the government to come out with solutions? We are not intruding into the Islamic affairs or the affairs of the Muslim. What we are asking are for the rights of the non-Muslims. So if the government is not going to give it, then the repercussion is going to be bad. Perhaps the next election.
The government is not doing anything to solve this particular problem. That is on religion, religious conversion, the death of disease, disease who have died, and the religious status of a dead person. So the government is not doing anything about this. In Kaliammal's case, it has been it's going to be almost 6 years. This thing is not solved.
There are 3 dates of conversion. In the 11th of April 2004. Then it's 22nd of April 2004. Then we have got one more dates mentioned to her. See, so there are 3 different dates. So where are we going to adduce the evidence to see is he a real convert? And the person so-called who has converted him has to come and testify. Because as far as the family is concerned, he is not a convert. So how are we going to find out? See, Nyonya Tahir case can be distinguished from this case. Nyonya Tahir's case, Nyonya Tahir was a born Malay, a born Muslim. It's a different issue altogether. If their family wishes to succumb to the Sharia court, that doesn't mean each and every non-Muslim has to succumb to the Sharia court. As you have your right, we have our right. So we still say that the remedy is in civil court. And this is the historical breakthrough where a person can come to court but has got no remedy. That is Kaliammal. Kaliammal can come to the civil court, but she has got no remedy. Raipan's case was another one more. Can come to the court, but no remedy. Okay? So this is very serious.
We have to rely on the decision by the court of competent jurisdiction. So in this case, the competent jurisdiction, the court of competent jurisdiction is the Syariah Court. Because from the there are many highest court authority on this. Sun Seng, then Dalip Kaur, again few Supreme Court and Federal Court decision, which earlier on has determined that the issue of determining a Muslim's faith, whether he has converted out or he still remain or he died as a Muslim, is for the Syariah Court to decide. So even though we wait for the, in this case, in this particular case, the hospital decide to wait for the decision of the High Court, but we have to, or we should respect the decision by the Syariah Court. And furthermore, it is the decision of the High Court itself to abide by the decision of the Syariah Court. When the learned High Court judge decide that the Syariah Court has jurisdiction, and the High Court has no jurisdiction to determine whether Allah Yarham Muhammad Moorthy died as a Muslim or otherwise. That is our position.
So what do you think are the chances of striking out the appeal?
Of course, we are always confident in our case because we have, I think, it's a long list of the authorities in our favor. In favor of the Syariah Court, which says that matters to determine the matters of Islamic law or doctrine, it is within the Syariah Court jurisdiction. It is there in the Constitution. Why should we argue? It's there in the Constitution already. The important point is for us to respect what we have in the Constitution. That is the kedaulatan undang-undang dan keluhuran perlembagaan. That is all about. So if we want to step further to deny or to transgress the jurisdiction of the Syariah Court, then it creates chaos.
What about their contention that the widow was not given a chance to be heard during the Syariah Court proceedings?
That is the statement from the bar. That's why I stood up and I replied that is the statement from the bar. There's nowhere in the affidavit to say that she denied that she has no notice about the trial in the Syariah Court. In fact, we have evidence, and my colleague has states that she was informed, but she know that we are going to take the Syariah Court order. But earlier, from the very beginning, the lawyers state their stand that no Syariah Court order. That is the problem. Different with the case of what we call the Seremban case, where the Nyonya Tahir case. The Nyonya Tahir case, the family, the daughter and the son, they came to court and they testify to the extent that the mother have professed the Buddhism. So they testify in court. So the court accept, and the Syariah Court accept that she was Buddhism and declared that she died not as a Muslim. I think that's proof that the Syariah Court have, discharged is fair and justice even to the non-Muslim.